John G. Roberts Jr. John G. Roberts Jr., appointed Chief Justice in 2005 by President George W. Bush, is known primarily as an institutionalist who prioritizes the Supreme Court's legitimacy and public trust. Though generally conservative, Roberts has often taken a pragmatic approach, sometimes siding with liberal justices in high-profile cases to avoid sharp political swings in the law. He authored the pivotal opinion upholding the Affordable Care Act in NFIB versus Sebelius, 2012, a decision that disappointed conservatives but cemented his reputation for independence. Roberts favors narrow rulings, judicial restraint, and incremental change rather than sweeping ideological shifts. As Chief Justice, he also plays a strategic role in assigning opinions and shaping the court's tone. His leadership style emphasizes stability, respect for precedent, and the court's role as a nonpartisan arbiter rather than a political weapon. Clarence Thomas. Clarence Thomas was sworn in 1991 after being appointed by President George H.W. Bush and is the longest-serving justice currently on the court. He is the court's strongest advocate of originalism, arguing that constitutional meaning is fixed at ratification and that wrongly decided precedents should be overturned regardless of age. Thomas has repeatedly criticized substantive due process, calling for reconsideration of cases such as Griswold v. Connecticut in 1965, Roe v. Wade in 1973, Lawrence v. Texas in 2003, and Obergefell v. Hodges in 2015. In his concurrence in Dobbs v. Jackson in 2022, he explicitly argued those precedents lack constitutional grounding. Thomas also seeks to dismantle the modern administrative state, advocating sharp limits on agency authority in cases like West Virginia v. EPA in 2022. His jurisprudence favors strong federalism, broad gun rights, and minimal judicial policymaking. Samuel A. Alito Jr. Samuel Alito, appointed in 2006 by President George W. Bush, is a reliable conservative vote known for favoring law enforcement, religious liberty claims, and executive authority. He was the author of Dobbs v. Jackson Women's Health Organization, 2022, which overturned Roe v. Wade and eliminated federal constitutional protection for abortion, returning regulation to the states. Alito also wrote Burwell v. Hobby Lobby, 2014, allowing closely held corporations to refuse contraceptive coverage on religious grounds, and McDonald v. Chicago, 2010, incorporating the Second Amendment against the states. He frequently dissents in favor of police powers and against expansive voting rights interpretations. Alito rejects broad readings of the Establishment Clause and is skeptical of administrative agencies exercising regulatory authority without clear congressional authorization. Sonia Sotomayor. Sonia Sotomayor was sworn in 2009 after being appointed by President Barack Obama and is one of the court's most consistent liberal justices. She emphasizes empathetic judging, experiential understanding, and the real-world impact of court decisions, particularly on minorities and marginalized groups. Sotomayor dissented forcefully in Shelby County v. Holder in 2013, arguing that weakening the Voting Rights Act ignored ongoing racial discrimination. She dissented again in Dobbs v. Jackson in 2022, warning that overturning Roe v. Wade from 1973 undermined bodily autonomy and threatened other privacy-based rights. In criminal law, she has repeatedly criticized expansive police powers, dissenting in Utah v. Strieff in 2016 and arguing that unlawful stops erode Fourth Amendment protections. Sotomayor has also defended broad affirmative action frameworks, dissenting in Students for Fair Admissions v. Harvard in 2023, where the court ended race-conscious admissions. Her jurisprudence centers on civil rights, voting access, reproductive freedom, and strict limits on governmental overreach. Elena Kagan. Elena Kagan was sworn in 2010 after being appointed by President Barack Obama and is known as a strategic, coalition-building liberal. She often writes narrowly tailored opinions designed to build cross-ideological agreement and preserve precedent. Kagan authored the majority opinion in Fox television stations, FCC, in 2012, holding that the FCC's indecency enforcement violated due process fair notice requirements. She joined the majority in Bostock v. Clayton County in 2020, applying textualist statutory interpretation to hold that Title VII prohibits employment discrimination based on sexual orientation and gender identity. Kagan has consistently opposed shrinking administrative authority, dissenting in West Virginia v. EPA in 2022, where the court limited EPA regulatory power under the Clean Air Act. She also dissented in Students for Fair Admissions v. Harvard in 2023, arguing that race-conscious admissions were consistent with equal protection precedent. Her jurisprudence strongly favors civil rights enforcement, federal regulatory capacity, and institutional stability. Neil M. Gorsuch. Neil Gorsuch was sworn in 2017 after being appointed by President Donald Trump and is a committed textualist and originalist, particularly in statutory interpretation. He authored Bostock v. Clayton County in 2020, where he wrote the majority opinion holding that Title VII's ban on sex discrimination applies to sexual orientation and gender identity, relying strictly on statutory text rather than legislative intent. Gorsuch has also been a strong defender of religious liberty, joining the majority in Kennedy versus Bremerton School District in 2022, which allowed a public high school football coach to pray on the field after games. He has consistently criticized expansive administrative power, authoring West Virginia versus EPA in 2022, which applied the major questions doctrine to limit agency authority without explicit congressional authorization. In criminal cases, Gorsuch often sides with defendants on Fourth and Sixth Amendment grounds, emphasizing jury rights and procedural fairness. Brett M. Kavanaugh. Brett Kavanaugh was sworn in 2018 after being appointed by President Donald Trump, following one of the most controversial confirmation processes in Supreme Court history. His nomination was delayed by sexual assault allegations from Christine Blasey Ford concerning events alleged to have occurred in the 1980s, which Kavanaugh denied under oath. The Senate held televised hearings and ordered a limited FBI investigation before confirming him by a narrow vote, sharply polarizing public opinion and the court's image. Jurisprudentially, Kavanaugh is a conservative institutionalist who favors limiting federal agency power, joining the majority in West Virginia versus EPA in 2022 to apply the major questions doctrine. He voted with the majority in Dobbs versus Jackson in 2022, overturning Roe versus Wade from 1973, but wrote separately emphasizing state-level decision-making. He often supports executive authority and religious liberty while favoring incremental legal change. Amy Coney Barrett. Amy Coney Barrett was sworn in 2020 after being appointed by President Donald Trump, following a rapid confirmation process that occurred weeks before the 2020 presidential election. A former law professor and clerk to Justice Antonin Scalia, Barrett is a committed originalist and textualist closely aligned with Scalia's judicial philosophy. She joined the majority in Dobbs versus Jackson Women's Health Organization in 2022, helping overturn Roe v. Wade from 1973, and has generally favored returning abortion regulation to the states. Barrett has also voted to expand religious liberty protections, joining the majority in Kennedy versus Bremerton School District in 2022. In administrative law, she has supported limits on agency authority, voting with the majority in West Virginia versus EPA in 2022. While relatively new to the court, Barrett has shown openness to reconsidering long-standing precedent and emphasizes constitutional text over policy outcomes. Ketanji Brown Jackson. Ketanji Brown Jackson was sworn in 2022 after being appointed by President Joe Biden, becoming the first Black woman to serve on the Supreme Court. Prior to her appointment, she served as a federal public defender and later as a U.S. district and appellate judge, experience that strongly shapes her jurisprudence. Jackson joined the dissent in Dobbs v. Jackson Women's Health Organization in 2022, arguing that overturning Roe v. Wade from 1973 removed constitutional protection for women's autonomy. She has taken a broad view of federal regulatory authority, dissenting in West Virginia versus EPA in 2022 against application of the major questions doctrine. In criminal law, Jackson has emphasized proportionality and due process protections, notably during sentencing-related cases involving federal guidelines. She also dissented in Students for Fair Admissions versus Harvard in 2023, opposing the court's decision to end race-conscious admissions. Her approach favors civil rights enforcement, access to justice, and a restrained use of judicial power.